In sum, Your Honor, I am not sure what advice was provided to the defendants by their counsel. I am not sure, other than taking at their word in their statements on social media out to the public, as to what their true intentions are. But this court issued an order. This court issued a second order. And the order of the writ, by their noncompliance, is being defeated. It is not for them to second guess this court. It is ironic to me that one of their chief complaints about one of the nominees, Ms. Julie Adams, was that she filed a case seeking in the previous Board of Election term as to whether or not she had to, as a duty, as a member of the Board of Elections, to certify the election. And when the court said that she did, she ultimately complied with that. Yet now they want to be on the other side of that argument. And now they're challenging an order of the court, and they're saying that they don't have to comply. It's pretty rich. This is not something that we filed lightly. It's not something that any of us expected when we filed our initial petition, that after obtaining a writ from the court, we would have to come back before the court again and seek and argue a motion for reconsideration or stay. We certainly contemplated that was a possibility. We certainly contemplated that they might have filed a notice of appeal and sought an expeditious review of this situation. What we never contemplated was that something so egregious as this court would say, here's my writ, you must follow it. You're aware of the law that says that it has to be followed immediately. You refuse at the first hearing, despite knowledge of that law, to abide by the court's order.
Well, just you raised that other case. That was Adams versus Fulton County, and I have that on Westlaw right here on my iPad because the Wi-Fi is not working in here right now, but I do have access through my cellular on this device. So, interestingly, that case related to the interpretation of the word shall.
Yes, Your Honor.
Which is what this case revolves around, albeit in a different code section. But the Court of Appeals cited one of the same cases that I looked at, Eternal Vigilance is the short name of it, a 2025 Georgia Supreme Court decision. And they said, quoted, the word shall is generally construed as a word of command. The import of the language is mandatory. Based on the foregoing, Adams' contention, and Adams is one of your
She's
nominees.
One of the nominees,
yeah,
yes, Your Honor.
That the trial court erred in declaring she had a mandatory duty to certify the election results is without merit. And as I noted, that's one of the cases that I looked at in making my decision, which that was the position of Fulton County in that case, which just came down in July, which it makes this case all that much more interesting. All right.
Can I point out one thing?
Let me respond to that.
I'll come back to you in just a minute.
Thank you.
Your Honor, and that's exactly right. We actually cited that in our reply before the court ordered on its writ of mandamus. The difference of the distinguishment, and again, we think the case law is clear as the word shall, and we're not here to relitigate that. What we are here for this court to consider and review is the difference in that case is that upon that order by the court, whether she liked it or not, she complied. And here, upon this court's order, whether the commissioners liked it or not, they're refusing to comply. They are, in a nutshell, attempting to seek someone, to keep someone off the board when they won't follow the law either. Your Honor, this is, again, extraordinary relief. This is not something we've requested lightly. We have laid out the different types of contempt that are available before the court. We also believe that our attorney's fees are appropriate in this instance. And we leave it in your able hands. We believe that everything that the court has stated in its orders to date has been well reasoned. It has been based on the law. And we would ask you, again, to review the law and look to the law, not to the propositions without any authority or the general arguments that the defendants are putting before the court today. Thank you.
Thank you. And I'm going to let Mr. Samuel respond, and you'll get one more word. And Mr. Samuel, yes, what did you want to add?
I think the real irony is that it was an appeal in the Adams case. And, you know, despite the fact that Judge McBurney ruled against her, nobody said, and if you don't do what Judge McBurney says, you know, upstairs here, you're going to be held in contempt. She appealed. That's how they got to the Court of Appeals and ultimately maybe the Supreme Court. But that's what we're asking for, is to have the same right that Ms. Adams had. And I would also point out, Ms. Adams wasn't an elected official, you know, like she was an appointed official. And there's a difference between that and not having a constituency. And in our case, we are not saying that shall was voluntary. That's not, we put that in our original brief, and everybody agrees the word shall often means must. I recognize that. Sometimes it does, sometimes it doesn't. We cited cases to you where sometimes it doesn't. And Georgia cases, it's a malleable word. We accept the fact. You're ruling that the word shall means shall appoint. The question is, before us today is, does shall mean you must vote? That's the problem here, is that you are telling elected officials, not you must appoint, you shall vote, and you shall vote yes. If we're wrong, Judge, the Court of Appeals will tell us, just like they told Ms. Adams. And then she complied. That's all we're asking for, is the right to appeal, have a meaningful appeal, and not have the plaintiffs, you know, then say, oh, by the way, this is all moot, they're on the board, nothing you can do about it. And even if they did do that, I think we both recognize that our agreement to make an issue justiciable is not binding the members of the Court of Appeals. Okay, I think that's all.
Thank you, Mr. Samuel. Anything else from the plaintiff?
One quick word, Your
Just
Honor.
limited to responding to this.
Yes, Your Honor. Keep it short.
One word.
One word.
I hear that all the time when I have lawyers stand up and say, just a couple of questions.
Just briefly.
Yes.
Your Honor, on the mootness argument, we have taken this position in open court. We have cited what we believe to be very good case law. There are numerous instances in which the Court of Appeals or the Georgia Supreme Court has found that these types of issues are not moot. It is, again, pretext. It is not the reason for the underlying motive that they are not following this court's order. And frankly, Your Honor, they had an opportunity to raise these arguments, the mootness at the motion to stay. We're not here to re-litigate that today. We're here to decide what to do upon their failure to abide by the writ and their failure to acknowledge that this court warned them in their last order that it would be taking up contempt if they failed to abide. They made a conscious decision to willfully disobey this court's order, and they have their opportunity to appeal. We are not going to take a separate position on appeal after standing in front of this court today that it's somehow moot. It would have to be raised to a sponte by the Court of Appeals. And again, the doctrine of capable of repetition but escaping review will allow this case to proceed. They can have their day in court, but they need to follow this court's order, follow this court's writ, and appoint the two nominees as required by the Georgia General Assembly as required by this court's order in accordance with the law. Thank you.
Thank you. And as I indicated, I don't generally rule from the bench. I have followed that practice for 35 years or so now on the bench, and so I will take this. I'll review your pleadings, but there was some mention that perhaps some individuals had filed something. I don't know if any of them want to be heard.
It's on Odyssey this morning. I got
Okay.
it.
And Your Honor, I have not even read or reviewed those. If there is something that, we don't believe that it's necessary, or we're not even sure that they were proper filings.
Well, I'll take a look at the docket if the system's working. I know they did an update over the weekend, and sometimes those take a while to recover from. Yes.
Your Honor, I'm Allegra Lawrence Hardy. I'm the lawyer who filed. So just wanted to let you know that I'm here in court.
All right, thank you. And I'll have a decision today, and that'll be filed with the clerk and transmitted electronically, I'm sure. Thank you. It's always a pleasure.
Thank you, Your Honor.